I spent 28 years prosecuting these crimes. Most of them were completely preventable. My name is James Harlow. I served as a prosecutor and district attorney in Georgia for nearly 3 decades. My career was built on financial elder abuse cases, estate fraud, and family exploitation. I put people in prison for exactly the kind of betrayal I am going to describe to you today. I spent those years building case files, gathering evidence, working with investigators and forensic accountants, and standing in front of juries asking them to hold people accountable for what they had done to the most vulnerable members of our society. But here is what those 28 years taught me above everything else. By the time I had a file on my desk, the damage was already done. The asset was already gone. The money was already spent or hidden or transferred. The house was already in someone else's name. I was cleaning up after catastrophes that had been set in motion by a single signature, months or years earlier, in a notary's office or a county recorder's office, in a conversation between a parent and a child that no one else witnessed. I am not in that office anymore. I retired because I concluded that the most useful thing I could do with the knowledge I have accumulated is to use it before the crime happens, not after. I am going to tell you about a case, and then I am going to tell you what the law cannot do, and then I am going to tell you what you can do instead. Margaret Hensley was 76 years old when this began. She lived in Savannah, Georgia. She had spent 45 years working as a librarian, first in the public library system, and eventually as head librarian at a mid-sized branch where she had been for the last 22 years of her career. Library suited her. She was methodical. She knew how to organize information. She understood documentation. She was the kind of woman who read the fine print, who kept records, who filed things correctly. She was not naive or careless. Margaret had been widowed 3 years before this case began. Her husband passed away in 2000 after a long illness. They had no significant savings beyond the house. He had medical expenses in his final years that had consumed most of their liquid assets. What remained when he was gone was a property in Savannah that Margaret had lived in for 28 years. The house was fully paid off. It was valued at approximately $198,000. That was everything. Not a retirement account, not a pension beyond what the county provided, not stocks or bonds or investments, just the house. The house was her security, her independence, and the last tangible thing she had built with her husband. She had one child, a daughter named Linda. Linda was 49 at the time. She lived in the Savannah area. By most accounts, she had a reasonable relationship with her mother. They spoke regularly. They had dinner on Sundays sometimes. Linda had a job, a household of her own, and what appeared to be an ordinary life. There was nothing in Margaret's description of Linda that would have signaled danger. That is one of the things that made this case difficult. There was no prior pattern I could point to, no previous financial disputes, no documented history of dishonesty. Just a daughter who one day decided to do something that destroyed her mother's life. In April of 2003, Linda came to her mother with a proposal. Linda said she had been thinking about Margaret's situation. She was concerned, she said, about 2 things. The first was probate. If Margaret passed away with the house still in her name, the estate would go through probate court. That would cost money and take time and create paperwork and legal fees. The family would have to wait while the court processed the estate. Linda said this could be avoided if the house was in Linda's name already. Simple, clean, no probate when the time came. The second concern Linda raised was Medicaid. If Margaret ever needed nursing home care, she said, the government could pursue a claim against the house to recover the cost of that care. But if the house was already in Linda's name, the government could not reach it. It would be protected. It would stay in the family. Margaret's hard-earned asset would not be consumed by a system that had not helped her earn it. This reasoning had the shape of love. It had the texture of planning. It sounded like a daughter who had thought carefully about her mother's future and arrived at a protective solution. The language was practical and caring. Linda framed it as something she was doing for Margaret, not to her. Margaret did not consult an independent attorney. She had been a librarian. She trusted information. She trusted her ability to understand things. But she trusted Linda more than she trusted her own skepticism, and that was the difference. In April of 2003, Margaret Hensley signed a quitclaim deed at a notary's office in Savannah, Georgia. Linda was present. The notary witnessed the signature and certified that it had been made voluntarily. The deed was filed with the county. Margaret's name was removed from the property. Linda's name was on it now. Margaret drove home from that notary's office and went about her life. She paid her utility bills. She maintained her garden. She cooked. She had her routines. The deed was a piece of paper she had signed, and paper felt abstract compared to the life she was living in that house. She did not feel any differently about the house the morning after she signed. She still thought of it as hers. That is the nature of trust. It delays comprehension. 6 months after the signing, Margaret noticed something unusual. Certain pieces of mail that she expected to receive had stopped arriving. A statement she had been expecting from her homeowner's insurance had not come. A renewal notice. A document she could not quite identify but knew she should have received. She called Linda and mentioned it. Linda said it was probably a billing change, an administrative update, nothing to worry about. 3 months after that conversation, 9 months after the deed transfer, someone knocked on Margaret's door. A real estate agent was standing on her porch. The agent introduced herself and said she was there to schedule a showing. "Your home is listed," she said. "We have interested buyers, and I would like to set up an appointment to bring them through." Margaret did not immediately understand what she was hearing. She asked the agent to repeat herself. The agent said it again. The house was listed for sale. She was there to schedule showings. Margaret called Linda from inside her own home. She was standing in her kitchen, in the house where she had raised Linda, in the house she had lived in for 28 years, with a real estate agent waiting on her porch. Linda answered. Margaret asked what was happening. Linda said, and I am quoting from what Margaret reported to me, "Mother, the house is mine legally. You signed the deed. I need the money. I am selling it." That is what was said. Not "I am sorry." Not "I did not mean for it to happen this way." Not "this is difficult for me." Just "the house is mine legally. You signed the deed. I need the money." Margaret was 76 years old. She called my office the next morning. I was then the district attorney for Chatham County, Georgia. I took the case personally because of what it involved, and because of what Margaret represented to me when I met with her. She came to my office prepared. She had brought the deed. She had brought the insurance documents she had found. She had written down a timeline. She was a librarian. She documented things even when she was the one being harmed. I opened an investigation. I classified the case under Georgia's financial exploitation of elder persons statute. I assigned an investigator. We gathered every document we could find: the original deed, the title records, the real estate listing, the communications between Linda and the real estate agent, the communications between Linda and the lender, because Linda had also taken a small loan against the property in the months before listing it. We subpoenaed bank records. We interviewed the notary who had witnessed the signing. What I found was thorough and clear, and almost entirely useless to me as a prosecutor. Margaret had signed the deed voluntarily. The notary's records confirmed this. She had been asked the standard questions. She had indicated understanding. She had signed without hesitation. There was no evidence that Linda had threatened her or coerced her physically. There was no evidence that Linda had forged her signature. Margaret had been mentally competent when she signed. She had at the time a complete understanding of who she was and where she was and what a notary office was. What Linda had done was frame a transfer of ownership as an act of love and protection, while omitting the information that would have changed her mother's decision. She had said the words that made the transfer sound safe. She had not said the words that would have made the risk clear. That is not the same as fraud in a manner that a criminal court can address. That is, unfortunately, something closer to how a great deal of financial exploitation of the elderly actually works. The legal question I faced was this: could I prove beyond a reasonable doubt that Linda Hensley had committed financial exploitation of an elder through fraud, deception, or misrepresentation? Could I prove that she had used the relationship to obtain the property through means that constituted a crime rather than a gift? The signature was real. The transfer was voluntary as the law defines voluntary. Margaret had not said no. She had said yes, in the presence of a notary, on a standard form, at a time when she was legally competent to make that decision. Linda's position was that her mother had made a gift, that they had discussed the probate concerns and the Medicaid concerns, that Margaret had understood what she was signing and had chosen to proceed. I could not disprove that narrative beyond a reasonable doubt. I had Margaret's account of the conversation, but I had no recording, no written documentation of what Linda had specifically said, no witness. The notary had witnessed the signing, not the conversation that preceded it. I had motive, but motive alone does not constitute proof. I had outcome, but outcome alone does not tell you whether the mechanism was criminal or merely mercenary. I closed the criminal case. I drafted the closing memo myself. I sat at my desk and wrote the words that ended Margaret Hensley's chance at a criminal remedy. And I filed them, and then I called her to explain. She was quiet on the phone when I told her. She did not ask me to reconsider. She had spent 45 years working in institutions. She understood what a decision was when one had been made. She asked me what she could do next. I told her about the civil lawsuit option. A civil suit for undue influence or breach of fiduciary duty requires a lower standard of proof than a criminal case. Not beyond a reasonable doubt, but a preponderance of the evidence, meaning more likely than not. That is a more achievable threshold when you have a parent, an aging widow, being persuaded by her daughter to sign away her only significant asset, using arguments about protection that were factually misleading. Margaret hired a civil attorney and filed suit. The case was long and expensive, and hard in the way that civil litigation against someone who shares your blood is always hard. Linda contested every claim. She produced evidence that Margaret had attended the signing and answered the notary's questions, and had not expressed any hesitation. She argued that the discussion had been honest, and that Margaret had been a willing participant. Depositions were scheduled. Motions were filed. Discovery went on for months. During all of it, the house was still listed. Linda had priced it to sell, and while the lawyers argued, a buyer appeared. A couple who had no connection to any of this, who had found the listing through a real estate website, who had done their due diligence on the title and found nothing to concern them. They made an offer. Linda accepted. The sale closed before the civil case reached trial. The house sold for $205,000. The money went to Linda. When the case eventually came to a judgment, the judge found in Margaret's favor on the undue influence claim. Linda was ordered to pay restitution. But Linda did not have the cash. The house was gone. The proceeds had been used to pay debts, and what remained was distributed through various accounts that had since been closed or emptied. Margaret received nothing of substance. A judgment against someone with no accessible assets is a piece of paper. It is a moral statement without a financial equivalent. Margaret moved into a Section 8 apartment in Savannah. She was 78 years old. She had worked for 45 years in public service. She had been careful and organized and systematic throughout her life. She was now dependent on government housing assistance because the legal system, including the full efforts of the district attorney's office, could not move fast enough to prevent an irreversible harm. I want to be specific about what the system failed to do And why? Because I think it matters for how you protect yourself. Criminal law in this country is built to punish acts of clear deception, coercion, and force. When someone steals from you by pointing a gun, that is easy to prove. When someone steals from you by saying words that were technically true but strategically incomplete during a conversation you had voluntarily, while you were mentally competent, while you were signing a legal document in front of a notary, that is much harder to prove as a crime. The signature is real. The consent is legally presumed. The law does not distinguish between a gift made with full understanding and a gift made with partial information, unless you can prove the deception with evidence that meets a very high standard. Civil law moved slowly, too slowly. By the time a judge could rule on the merits, the asset had been liquidated. The house had passed through 2 more owners. The money was gone. The judgment was abstract. I have seen this pattern repeat itself in case after case throughout my career. The civil system produces rulings that arrive after the damage is permanent and produce remedies that are either too small or unenforceable. The system functions as designed. The design is inadequate for this kind of harm. What would have protected Margaret? The first thing is independent legal advice before any transfer of any asset. Not advice from someone Linda knew. Not advice from a notary. Not advice from a neighbor who had done something similar. An independent attorney who had no relationship with Linda, who owed nothing to anyone in that family except Margaret, who would have asked the question that no one asked. What happens if Linda sells the house while you are alive? What happens if Linda takes a loan against it? What happens if Linda gets divorced and the house becomes part of a settlement? What happens if you need the house back and Linda says no? That attorney would have answered those questions before the deed was signed. Margaret would have heard the answers. She would not have signed. The second thing is an understanding of what a quitclaim deed actually does. Not what probate avoidance sounds like. Not what Medicaid planning sounds like in theory. What a quitclaim deed actually does. It removes your name from the title. It places another person's name in its place. That person can sell the property without your consent. That person can mortgage it, borrow against it, encumber it. They can list it while you are living in it. They can accept a buyer while you have nowhere to go. The law does not care that you intended it as a gift with informal conditions. The law reads the deed. The deed says the property belongs to the named owner. That owner has all the rights that ownership entails. The third thing is a different instrument, a life estate deed, a beneficiary deed, a revocable living trust. These are legal tools that exist precisely to solve the problem that Margaret was trying to solve without the risk that Margaret encountered. A life estate deed keeps you as the life tenant, meaning you retain the right to live in and use the property until you die. The remainder interest goes to your chosen beneficiary. But while you are alive, the beneficiary cannot sell the property without your signature. They cannot mortgage it without your participation. Your occupancy is legally protected. The Medicaid recovery issue Linda raised is addressed in most states by the 5-year look-back rule regardless, and an elder law attorney would have explained that a life estate deed or a revocable trust handles it correctly. The probate concern Linda raised is addressed entirely. Everything Linda said she wanted to accomplish could have been accomplished without Margaret giving up her rights. Margaret did not have to give up her rights. She was told she did. That was the lie. Not a lie in a document, but a lie in a framing, in an omission, in the things that were not said in that conversation. The truth is that there are legal instruments designed to protect parents in exactly this situation. Margaret did not know about them because no one with a professional obligation to her interests told her about them. I do not talk about Margaret's case without thinking about what it cost her in human terms beyond the financial. She spent the last decade of her working life building something. She built it slowly, the way you build something on a librarian's salary. When her husband died, the house was the only thing she had left. When Linda took it, Margaret lost not just an asset, but the proof that her life had amounted to something tangible. She lost the kitchen where she had cooked dinner for 30 years. She lost the garden she maintained. She lost the physical container of every memory she had made in that house. She moved into a one-bedroom apartment she did not choose, in a building she would not have chosen, with neighbors she did not know, because the only home she had known for 28 years was sold by her daughter while she was living in it. I could not give that back to her. Neither could the civil court. Neither could any legal instrument available to me once that deed had been signed and the property had been sold. If you are watching this, you have time that Margaret did not have after that document was signed. Share this video with someone who needs to hear what I just told you. Tell them what the law cannot do. Tell them what Linda said and what the system could not answer. Tell them that Margaret Hensley worked 45 years and ended up in Section 8 housing because of a single conversation and a single signature. Subscribe to this channel. Comment below. Tell me what situation you are facing, or what you have seen, or what question you have that no one has answered clearly. I spent 28 years building cases against people who did this. Now I am using what I know to prevent it. Most of these crimes were preventable. This one was preventable. Make sure yours is too.